In times of crisis such as the COVID-19 pandemic, employers and employees alike need to be aware of their rights. Employers want to balance their business concerns as well as their employees' concerns. On the other hand, employees want to know what they're entitled to in cases where they're placed under redundancy, in cases where their services are terminated, in cases where they're put on short-term work, and in cases where they're put on unpaid leave. The question here is, what is fair and what is unfair? This episode is going to introduce a series on employment and labor relation matters. I will first discuss redundancy. This is Life and Law. My name is Awor Owor. Questions on employment and labor are dealt with under the following statutes. So first of all, the Constitution of Kenya 2010, second, the Employment Act 2007, and third, the Labor Relations Act 2007. In addition to this, labor-related questions are also dealt with under international conventions that Kenya is a party to. First, we're going to define redundancy. So redundancy can be defined as the loss of employment, career, job or occupation by involuntary means through no fault of the employee. It can also be defined as loss of employment by the initiative of the employer where the services of the employee are rendered superfluous. Redundancy is dealt with under Section 40 of the Employment Act. This particular section outlines the conditions that the employer needs to comply with before terminating the contract of service on account of redundancy. So the first condition that the employer needs to comply with is notification. How do you notify the employee that he is terminated on account of redundancy? So notification comes in two folds, whether the employee is part of a trade union or not. The first part is where the employee is part of a trade union. So the employer will notify the trade union and not the employee, and also the employer will notify the labor office in charge of the area that the employee is employed. The second part is where the employee is not part of a trade union. So here the employer will notify the employee personally and also notify the labor office in charge of the area that the employee is employed. The second point on notification is that notification should be in writing. Third, the notification should state the reason for termination and also the extent of the intended redundancy. Fourth, the notification should be served to the employee or the trade union, depending on the situation, 30 days prior to the intended date of termination on account of redundancy. The third condition that the employer needs to comply with is selection criteria. So the question here is, how does the employer select the employee to be terminated on account of redundancy? So the employer needs to take into consideration due regard to seniority in time and the skills, ability and reliability of the employee. So the third condition that the employer needs to comply with before terminating the contract of service is dues to be paid to the employee. So there are circumstances where the trade union and the employer have come into a collective agreement. This collective agreement might provide for terminal benefits payable upon redundancy. So in situations where an employee is not part of the said trade union, the employer should not hold the employee at a disadvantage. That being said, the dues payable include in cases where the employee has unspent leave days, the employer should pay the equivalent of the unspent leave days in cash. The second point is in cases where sufficient notification was not issued to the employee. I said earlier that the sufficient notification is 1 month. So in such situations, then the employer should pay the employee 1 month's notice or 1 month's wage in lieu of notice. The third is severance pay. So the employer should pay the employee severance pay in the rate of 15 days of each complete year of service. So that is Section 40 of the Employment Act. Section 50 goes ahead to provide another condition that an employer needs to comply with. It's to do with the certificate of service. So the Section 50 states that an employer should issue a certificate of service upon termination of employment. So the certificate of service should include the employer's name, the employee's name, the time the employee has spent in the company. That means when the employee was employed and when the employment ceased. And I mean any other particulars that the employer fits right to put in this certificate of service. It is also important to note that the employer is not bound to give the employee any references, recommendation, or any notification to show performance of the employee. It is also important to note that if an employer willfully and negligently fails to issue a certificate of service, or yes, he issues a certificate of service, however, in that certificate of service, he includes statement that he knows to be false, then that employer will be committing a crime and will be liable to a fine of 100,000 or 6 months imprisonment or both. So I have discussed Section 40 and Section 50 of the Employment Act. So now Section 56 of the Labor Relations Act provides that officials of the trade union are allowed to visit the employer's premises to, among other things, represent the employee in the dealings with the employer. Another law that we're going to look at is international law conventions. So as per the Constitution of Kenya, international law becomes Kenyan law as long as Kenya is a state party to the particular organization. So Kenya is a state party to the International Labour Organization. Kenya joined ILO in 1964. So one of the ILO conventions is the Termination of Employment Convention, and Article 13 of that particular convention echoes what Section 40 of the Employment Act says. It also reiterates what Section 56 of the Labor Relations Act says. So with that, we can see we have been able to outline what the law says. Now tune in to the next episode where I will be giving a practical example of redundancy. Thank you for watching, and remember, haki iwe ngao na mlinzi.